This is Bloomberg Law with June Grasso from Bloomberg Radio.
This act of terrorism and the violence that stems from it is something that would not be tolerated in the city. We wanted to personally be here to show the symbolism of leading from the front.
It's never happened before. The mayor of New York City and the police commissioner meeting the aircraft carrying a murder suspect being flown in from another state. And it was quite a spectacle at a lower Manhattan heliport this afternoon as Luigi Mangione was escorted from a helicopter on the long walk to a waiting van, surrounded by dozens of heavily armed law enforcement officers in tactical gear, followed by Mayor Eric Adams and the police commissioner. The so-called perp walk was a complete departure from how federal authorities normally handle transfers of suspects. But the handling of the Mangione case by state and federal authorities seems to be a departure from the usual in so many respects. The latest, the federal government has now charged Mangione with murder in the shooting death of United Healthcare CEO Brian Thompson, charges that carry a possible death sentence, a development that Manhattan prosecutors didn't seem to have much notice of. Joining me is Palm Beach County State Attorney Dave Ehrenberg. Dave, the federal government doesn't usually do perp walks or photo ops. Why here?
Wow. This is an internationally watched case, and he's being treated differently. The reward money was larger and faster in coming. The attention given to it is much greater than any other case. He's a folk hero among some, and I think this is a statement meant that you're going to treat him like the criminal that he is as opposed to a big-time celebrity. But in so doing, it looks like they're treating him as a celebrity because they don't normally do perp walks. And so nothing about this case seems to be normal.
So murder is generally not a federal charge. New York City had 386 homicides last year. The country as a whole, almost 18,000. This involves the murder of one person that happened in New York City. Why is the federal government filing charges as well?
Well, if this was the Trump administration, I'd say it's because they don't trust the Manhattan DA. But this is still the Biden administration. And I think just because of the international interest in this case that they're coming in to make sure that nothing goes wrong at the state level. It's like a backup. But it is unusual because usually it's one or the other, not both. But in this case,
federal prosecutors have filed murder, stalking, and weapons charges against Mangione, and the charge of murder by firearm carries the possibility of the death penalty. Federal prosecutors haven't said yet whether they'll seek the death penalty because that takes a process in the Justice Department. Do you think they're likely to go that far?
I do think that based on Donald Trump's statements about this case, that in the next administration, they could seek the death penalty, even if they don't seek it initially, because right now there's a moratorium on the death penalty at the federal level. But that's going to change. And so, yes, I do think maybe that's one difference between the state and the federal systems here is that the death penalty is outlawed in New York, but a federal case can impose a federal death penalty. I think there would be a lot of outcry, though, because this guy's got a bunch of supporters, and I think that ultimately a jury will not give him the death penalty in this case, but the feds may try.
His attorney, Karen Friedman Agnifilo, issued a statement. Quote, the federal government's reported decision to pile on top of an already overcharged first-degree murder and state terror case is highly unusual and raises serious constitutional and statutory double jeopardy concerns. Is this double jeopardy?
Not really, because there's something called a separate sovereign doctrine. These are two different sovereigns, state and federal, and they can both file their own charges based on their own laws. And so you could have that. Now, in some states like New York, there are additional restrictions on states that then pile on. You saw that with Paul Manafort. In fact, the Paul Manafort indictment that came at the state level was thrown out by the courts because of double jeopardy concerns. Now, the feds, though, don't have the same type of restrictions, and federal law generally will permit a piggyback type of case like this, as long as it's not the exact same statute, which it's not. These are two separate statutes and two different types of penalties. In the federal system, you can get the death penalty. The state system, you don't. So I do think they'll move forward. And I do respect Karen. She's a great lawyer. She's a friend of mine. And I think she has an argument that the state does seem to be overreaching here with the first-degree murder charge. But I would disagree with her on her statement that the feds are engaging in double jeopardy in adding their own charges. There's a lot of case law that says they can do it.
I mean, a lot of times you see a state case fails or there are civil rights issues, and then the federal government comes in and tries the case on federal charges. But at this stage, before even his arraignment on the New York charge, is this unusual for the feds to come in?
Oh, it is unusual, yes. But there's nothing usual about this case. This case has attracted international interest. Everyone's still talking about it. You have people dressing up as him to praise him, to treat him like he's some sort of hero when he is not. And I think that's one of the reasons why the federal government is getting involved here. It's important to them and to a lot of people that there's not a precedent set that glorifies murder. And right now we're seeing too many people glorify this murder and treat him like a hero when he killed a father of two. And he did so by lying in wait, wearing a mask, waiting for him to walk by, and then shooting him in the back and then running away. Not quite an act of heroism.
I think the federal charges came as a surprise even to the Manhattan District Attorney's Office, because his attorney said that she wanted to get some clarity on what was happening, whether there were multiple investigations, because she was told to appear at 2 p.m. at state court, and then she ends up before a federal magistrate. It seems like feds and the state are not coordinating or talking at all.
Well, it wouldn't be the first time. We saw this most recently in the second assassination attempt against Donald Trump, where you have the feds seeking an indictment, getting an indictment against the attempted assassinator, and then you have the state of Florida doing a conflicting investigation that has led to state charges. So we're seeing these turf wars more and more. I don't think that's a sign of progress. I think that's a sign of the times, unfortunately. But if you think it's bad now, wait till you have Trump in the White House and a Democratic state of New York. They'll really go at it. Right now you have Democrats running both agencies, but that only will last for another few weeks.
And Manhattan District Attorney Alvin Bragg said the New York case will proceed in parallel with the federal case. What do you think will happen here? Which case goes to trial first? It seems like tough for the defense attorneys to be defending against both at the same time.
Right. Well, Luigi Mangione's family can afford to hire additional lawyers to ramp up their legal team to defend against both. Generally, the feds go first. Generally, the feds take precedence and the state will defer to them. The state here is saying they're not backing down. They're going to continue with their prosecution, and they filed first. So it just depends on the scheduling of the court. Since the state doesn't look like it's going to defer to the feds, I could see the state going first and the feds waiting for the state, or we'll see when Trump takes over the government and his U.S. attorney and his DOJ is fully in place, whether they try to expedite the federal case. So too early to say which goes first, but as of right now, the state has the lead because they got the first indictment.
The federal papers really went into detail, a timeline of his plotting, and they had additional evidence. Do you think that means that the feds have more information than the city, or they just decided to lay it out in a talking indictment, whereas the city didn't?
Yeah, the feds are used to issuing speaking indictments with more detail than at the state level. In fact, you saw when Alvin Bragg indicted Donald Trump, it didn't provide a ton of details that the press and the rest of us were looking for. The feds will provide more detail. They will provide more information. Doesn't mean they have more information. In fact, I think they're all playing off the same info, the same investigation, but the feds will provide more information, which is ironic because generally the feds are tight-lipped. Generally, there's lack of transparency at the federal level. But here in New York, there are no cameras in the courtroom at the state or the federal level. So I wish they would both be a little more transparent. But that's where New York is, and that's where the feds are when it comes to the courtroom.
Yeah, now let's go to the New York charges. And you mentioned the top charge, first-degree murder in furtherance of terrorism, and Bragg said that Mangione intended to intimidate and evoke terror with the killing. Is that an overcharge? Is he reaching there?
I respectfully do believe that they're reaching a bit. I think it's an easier case to prove second-degree murder, and I realize that they included second-degree murder, and they may want to push a compromise verdict, which would be second-degree murder, where he could face up to life in prison. But I do think when you add the first-degree murder charge, it feels like an overreach, and that could cost you some credibility in the eyes of jurors. You look at the prosecution of Daniel Penny, that's the ex-Marine who killed Mr. Neely on the subway. Well, they charged him with manslaughter, and a lot of us thought that was an overcharge. And apparently it was, because the jury couldn't reach an agreement, and then finally the judge threw it out. And then when it came down to the lesser charge, the easier charge, the jurors had enough and just said, no, acquittal. And that's the kind of thing that you worry about when you overcharge, that you have juror fatigue, you have juror mistrust at prosecutors. So you have to be really careful here. And I just don't think, based on what we know now, that you can confidently say that this was an act of terrorism. But maybe, they have access to information that the rest of us do not have. So we'll see. But as of right now, I do think it's a bit of a reach.
They could have been trying to push him into a guilty plea, but now that seems complicated with the federal charges. Would the defense only go forward with guilty pleas if they could reach deals with both the feds and the city?
No, it complicates things for the defense, because you could plead guilty to state charges and then still face federal charges. So you want a deal that will cover everything. And with the feds and the state seemingly in conflict with each other, that makes it harder for defense lawyers to say, all right, everyone, let's all come to the table. Here's one universal settlement. The feds may seek the death penalty. The state is looking for first-degree murder, but there is no death penalty there. So there's a lot of moving parts here. And you're correct when you say that with two different cases, maybe they want to ramp up with more attorneys. They can afford it. The defense has lots of money, because this is getting a lot more complicated.
Before she was hired to represent Mangione, his attorney Karen Friedman Agnifilo suggested on CNN that there might be an insanity defense here. By all accounts, the evidence against him is overwhelming. Is not guilty by reason of insanity the way to go here?
I don't think the insanity defense is a good defense here. I don't think that will play. And the reason is that to have an insanity defense, you have to have an established medical condition, and you cannot know the difference between right and wrong. Well, when you wear a mask and have fake IDs and meticulously plan for a murder, you're definitely able to distinguish between right and wrong. You know what you did was illegal. You know how we know? Because you planned for it to not be caught. And then after you ran away and hid and tried to conceal your identity, well, that shows you knew the difference between right and wrong. You knew what you did was illegal. You knew the consequences of your actions. So I don't think they have much of a chance at an insanity defense. Now, they could have a different defense to claim that he was under extreme emotional disturbance, which would make it more of a manslaughter case than a murder case. That could get you between 5 and 25 years in prison, as opposed to up to life in prison for murder. That may be a better defense, not a complete acquittal, but something less than murder. And then there's always the specter of jury nullification. It's a prosecutor's worst nightmare, where the jury just feels sympathy for the guy and ignores the evidence and ignores the law and then just sets him free. That's always a possibility when you're dealing with this kind of unusual case of a defendant who will probably take the stand and probably gain some sympathy from the public, if not members of the jury.
Jury selection is always important, but is it critical in this case?
Yeah, jury selection is always important. A lot of cases are won and lost in jury selection, and this one will be crucial. You're dealing with a progressive area, relatively speaking, in Manhattan, where people probably feel similarly to Luigi about insurance companies. But you got to just say this guy went too far. I mean, you really have to put your head in the sand and think we're just not a country of laws if you are going to sanction murder. So I do think that his defense that they had it coming is a bridge too far. But, he does have some claims that could show that he was under extreme emotional disturbance by saying that he had back surgery. Maybe he was taking pain pills. His family went through all this, and he just acted irrationally And this type of thing is more of a manslaughter case than a murder case. We'll see. But I don't think that Karen Friedman Agnifilo is out of defenses. I think she has a real legitimate chance to get him something less than life in prison.
Before I let you go, Dave, I want to get your take on a Georgia appeals court disqualifying Fulton County District Attorney Fani Willis and her office from handling the 2020 election interference prosecution of President-elect Donald Trump, citing the appearance of impropriety stemming from her relationship with a former member of the prosecution team. Although the appeals court denied Trump's bid to have the indictment tossed out, she's going to appeal, but do you think that case is going to die?
If she's off the case dies. I do not believe another DA is going to want to step into this case and pursue it with the zeal that Fani Willis did. I think that it will wither and die on the vine. Now, as far as what will happen, she's going to the Supreme Court of Georgia. I don't know which way they'll go. I did not think the appellate court was going to overrule Judge McAfee and disqualify her. So, boy, that surprised me. And so would it surprise me if the state Supreme Court overruled the appellate court? Perhaps. I don't know what's going to happen next, but this thing was a self-inflicted wound. This was a solid case against Trump and his cohorts, but because the DA hired a special prosecutor who she had a romantic relationship with, it muddled everything up, and now we're left with this.
Always a pleasure, Dave. Thanks so much. That's Palm Beach County State Attorney Dave Arenberg. Turning now to Supreme Court news, the justices are fast-tracking TikTok's challenge to a law that would ban the popular social media platform on January 19th if it isn't sold by its Chinese parent company. The court has scheduled a special argument session on January 10th to consider the law before it takes effect on January 19th. TikTok and its parent company say the law violates the Constitution's free speech protections, but the D.C. Appellate Court unanimously upheld the law earlier this month as a legitimate means of protecting national security and user privacy. Joining me is Professor Eric Goldman of the Santa Clara University Law School. He's co-director of the High Tech Law Institute. The court has scheduled arguments for January 10th with a special argument day, 2 hours of argument, double the usual time. How unusual is it, and what does it signify, if anything?
Every Supreme Court case is unusual. It's one of the rarest events in litigation. But this case is unusual for the Supreme Court's procedure. They've set up an expedited process that they don't normally follow, and it means that they're going to be moving fast, but they're probably also not going to be able to issue the kind of quality of opinions that we're used to. So they're probably going to have to cut some corners along the way as well. So this is an unusual case for them.
In the Bush v. Gore case, they ruled the day after they heard oral arguments and just 3 days after they agreed to take the case. Do you think with this expedited schedule, they're looking to do something before January 19th?
I don't think they would have built a schedule like this unless they plan to give some ruling before January 19th. But you mentioned Bush v. Gore, and that's actually a good example of the problems that are awaiting the Supreme Court. Not only was that opinion fragmented in the sense that every judge wrote for themselves, but also that opinion has been roundly criticized as being not the same kind of standard quality of judging that we expect from the Supreme Court. So the Bush versus Gore example is actually a cautionary tale for the Supreme Court. Odds are that they're going to issue multiple opinions and that it might not be to the level of quality that we want.
The justices could have acted on the emergency request by TikTok and blocked the law while the case moves forward. Wouldn't that have been an easier way to handle this?
As an outsider, it looks like what the Supreme Court should have done was put the law on hold until the Supreme Court could do a standard process for its review, not do this expedited corner-cutting approach. And I don't know why they didn't do that, but that's the choice they made, and so they've clearly decided that they're going to have to move faster.
Are they balancing the First Amendment against national security concerns and the court's deference to Congress and the executive branch in making national security decisions?
That's a good summary, but if you don't mind, I'm going to restate it a little bit.
Absolutely.
The D.C. Circuit, which heard the TikTok case and had sent the case up to the Supreme Court, said that the law was censorship, that the law censored TikTok and its users. but nevertheless that censorship was justified on national security concerns. That creates really two tracks for the Supreme Court to pursue. One track they could pursue is to say the law is censorship, and yet it survives, like the D.C. Circuit said, because the national security concerns overweigh the loss of free speech. Another track is that they could say, we agree that the law is censorship, and that's a reason why it should be struck down. And so the D.C. Circuit's opinion that presages the Supreme Court's review really set up the Supreme Court to answer that fundamental question: under what circumstances does national security override what is on its face, and everyone seems to agree, it's just censorship.
And I mean, do you have, based on their past opinions, do you have any feel for how this? I mean, they're usually. It seems like they usually defer on national security, and they're also big on First Amendment. I mean, do you have any feel?
It's hard to predict what the Supreme Court's going to do because there really are two different dynamics pushing them in opposite directions. Back in July, the Supreme Court issued a very strong endorsement of the First Amendment protections for social media. And so if we look at what the Supreme Court has said just a few months ago, they said, if it's censoring social media, that sounds like a First Amendment problem. On the other hand, you have this D.C. Circuit opinion that was a unanimous opinion from the lower court saying that the national security concerns here overrode free speech concerns. And the Supreme Court listens carefully to the D.C. Circuit. It's a well-respected court. They put together an opinion that was designed to be persuasive for the Supreme Court. So if we look at what the Supreme Court said in July, it looks like the TikTok ban should not succeed. If we look at what the D.C. Circuit advised the Supreme Court, it looks like the ban should be upheld. And so I don't know which strand is going to override the other.
The public still hasn't seen evidence from the government that China used the app to influence U.S. citizens or to steal data. Might the Supreme Court be looking for some of that evidence?
So there have been many closed-door discussions about the alleged national security concerns raised by TikTok, evidence that has not seen the light of day for the public. The D.C. Circuit's opinion made it clear that it was not relying on any of that hidden evidence, that they were relying only on the evidence that's been introduced into the public sphere. That then creates a dilemma because some people might find that evidence not credible, that it's a lot of smoke and mirrors, it's a lot of implications and inferences, but it's not exactly the kind of smoking gun conclusion that would dictate the potential loss of a major free speech right. So part of the challenge for the Supreme Court will be to decide what exactly is a threat to national security. How seriously can we take the evidence that's been presented in the public light, and will we agree with the D.C. Circuit's concerns, because not everyone does.
Some TikTok users seem to be waking up to the fact that it may be gone on January 19th. Do you think the court will address the concerns of the 170 million U.S. users?
I'm hoping that the court will be sensitive to the fact that not only does TikTok have free speech rights, but so do all the millions of users, millions of Americans who are talking to each other on TikTok. And even if we disregard TikTok's interests, we still ought to care about the conversations that are taking place by and among Americans on TikTok that are all in jeopardy due to this ban. The D.C. Circuit really didn't care about that issue. They just lumped it together under the broad heading of TikTok's concerns. They didn't otherwise pay attention to TikTok's users' interests. I'm hopeful the Supreme Court will be more sensitive to that, but we'll have to see.
Trump takes office after the TikTok ban goes into effect, if the Supreme Court doesn't do anything about that. He's been all over the map about TikTok. He met with executives of TikTok at Mar-a-Lago this week. He said recently he has a warm spot in his heart for TikTok. Let's say he does want to do something about it. What could he do?
By the time Trump takes office, either the TikTok ban will be enjoined permanently or temporarily, or it will be in effect. So the law has a mechanism that gives the president some discretion with respect to TikTok, but only Biden will be able to exercise that. So we'll know what Biden does before he leaves office, but by the time Trump gets there, that particular option in the statute to delay the effectiveness of the law won't be available to him. So at that point, Trump really has two choices if he really wanted to protect TikTok. First is he could go back to Congress and ask Congress to rethink its ban. I don't think that's going to go anywhere. Even Trump's most loyal fans have been very solidly against anything that looks like it would benefit China. And so I just don't think that even if Trump asks, he's going to get a majority of Congress to change their mind. The other thing that Trump can do is that he could ask the Department of Justice not to enforce the law, that the Department of Justice could take a voluntary stance that though the law is in effect, they're not going to devote any prosecutorial resources to it. Trump doesn't have the power to tell the DOJ what to do. He has to ask. In practice, if he asked the DOJ to do something or not, they would likely do it. However, that only works if everyone around the Department of Justice believes that the Department of Justice won't actually change its mind. And that depends on believing that Trump won't change his mind. And given how mercurial Trump is, how often he has changed his tune, I don't think anyone would believe the Department of Justice if it said that it wasn't going to enforce the law. That I just think that everyone would view that as a short-term statement subject to change and not make any decisions in reliance on it. So I really don't think Trump has any valid options to walk back the ban. He'd either have to go to Congress or he'd have to ask the DOJ to do something, which I don't think would really make a difference. So this ban is real, and it's unfortunate that so many Americans don't realize that this ban is coming for them.
So people say, well, I have TikTok on my phone. I'm still going to use it. Explain what happens if this ban goes into effect.
I'm still a little unclear about exactly what would happen post-ban. We know that new downloads will become extremely difficult, if not impossible. So the ban affects the app stores. The app stores are going to do whatever the government tells them to do. And so if the government tells them to take the apps out of their app stores, they'll do it. So in addition, other service providers in the U.S. are supposed to not provide support to TikTok. And I don't exactly know what implications that would have for the experience of the users who already have installed the app. I think what's likely to happen is that the app is going to start a death spiral. It won't happen overnight, but over time, people will invest less of their time, or content producers will invest less in producing TikTok content. And so over time, it becomes a ghost town. That might take months or years, but by stopping the inflow of new users and by making it harder for existing users to take advantage of it, I just think people will start to migrate elsewhere.
Yeah, in its papers, TikTok said that being shuttered for even 1 month would cause it to lose about a third of its U.S. users. So we see what would happen
and
there.
And it's not just losing the users outright. It's also that users are just going to invest less of their time, or content producers will invest less in producing good content. People are just going to take their marbles and play in some other playground. But the problem with the TikTok ban, and the reason why that's so legally significant, is that some conversations won't migrate anywhere else. They'll simply be lost. That there's certain ways that TikTok conversations work that don't work on other environments. And there's certain communities that develop on TikTok that won't replicate elsewhere. So though TikTok will become a ghost town and some people will migrate to other services, there's going to be some conversations that get lost in the equation, and that's the real free speech harm.
Have you heard anything new about a possible sale because of the ban? Although a lot of people say it's not a ban because it can be sold, so it's not a ban. I mean, there seems to be nobody who's stepping up to buy it.
Yeah, we don't know what's going on in backroom negotiations. We don't know to what extent they're not able to work out a price, or that the Chinese government is blocking the sale behind the scenes, or that there just isn't any interest in taking it over. It's really hard to reverse engineer why a sale isn't happening. But TikTok has been clear all along that that was not its game plan, that it was going to accept a ban over a sale. And from my perspective, the idea of sell or ban is really a ban. And yet the D.C. Circuit was open to the idea. All TikTok had to do was just sell. And from my perspective, I felt offended by that. I felt like that was really tone deaf.
Bloomberg intelligence litigation analyst Matthew Schettenhelm is giving TikTok a 30% chance of success at the Supreme Court. So do you think it's an uphill battle for TikTok at the Supreme Court?
I wouldn't put money on either side of the equation, TikTok winning or losing at the Supreme Court. I just view the risks as being too hazy to really make an educated gamble. Having said that, for those who think that TikTok has an uphill battle, they have good evidence to support that. The D.C. Circuit's opinion was a unanimous opinion, and the Supreme Court will absolutely pay attention to it. So the most recent statement in this case is TikTok loses, the ban succeeds. And so anyone who puts the money on that, I understand. But I also think that the Supreme Court is open to an alternative outcome, given what they said in July. So if other people put money on TikTok, I could see that as well.
So what are the other outcomes besides an outright win or loss?
One possibility is that the Supreme Court says that it can't reach a final decision and that additional work needs to be done by lower courts. So we get a non-answer from the Supreme Court. Another possible outcome is that the Supreme Court upholds parts of the ban and strikes down other parts. I don't really know what that looks like. We'd have to see. But the point is that it's not as easy as just does the Supreme Court uphold the ban outright or not, because there's a whole bunch of other tools in the Supreme Court's toolkit.
So we'll talk again on January 10th. Thanks so much, Eric. That's Professor Eric Goldman of the Santa Clara University Law School. Turning now to a murder conviction earlier this week. An acquaintance of Cash App founder Bob Lee was found guilty of murdering him on a downtown San Francisco street in April of 2023 and faces the possibility of life in prison. A jury rejected Nima Mamoni's claim that he'd stabbed Lee in self-defense after Lee, high on drugs and sleep-deprived, tried to attack him with a knife. Tuesday's verdict followed about a week of jury deliberations in the high-profile trial that featured more than a month of witness testimony. Joining me is Bloomberg legal reporter Malthi Nayak, who covered the trial. Malthi, start by telling us a little about Bob Lee and the reaction in San Francisco to the shooting.
So Bob Lee is a celebrated executive in the technology world in San Francisco. He's known as a coder, a super coder, in fact, who helped Google develop Android and also Square's Cash App, which he was an executive at and he was a founder of. So when he died, there was definitely a lot of reactions, especially, at first people thought it was possible that someone was just killed on the streets of San Francisco. And at the time, there was all this news about how San Francisco had sort of really spiraled into a state of lawlessness and that people could get shot and that there was drugs on the streets and, drug dealers and all these bad guys roaming around on the streets. So there was definitely a very strong reaction. People were sort of surprised that this had happened. And it was only later that we learned a little bit more about the facts and some grainy videos that then, the police shared. And then it appeared that he was actually seen, not far from the iconic Bay Bridge, tackling this other man. And they had some sort of an encounter and he was stabbed. And then there's also a video of him sort of walking away from this encounter. It seems like he then called 911 and was bleeding. So, yeah, it was definitely a strong reaction given that we don't hear a lot of such violent crime on the streets of San Francisco.
So what was the prosecutor's theory of the case? Why did they say the defendant did this?
So it's this very sort of interesting sort of tale about Nima Momeni and his sister, Kazar. And Kazar was friends with Bob Lee. And it turned out that, during the trial, there was all this sort of information and sort of testimony that came out about the drugs that, they were doing. And it turns out that one night, Bob Lee introduced her to a friend who was like a party host or a drug dealer, and they did some drugs together. There was some sort of like sexual assault that Kazar said she faced from this friend of Bob Lee, and she was upset about that. And then that night, Bob Lee and Nima Momeni ended up at the Millennium Tower, which is this building in San Francisco, luxury high-rise apartment, and they ended up at Kazar's house late at night, and I think Kazar had complained to her brother about what had happened, and he was upset with Bob Lee. But the thing is that it wasn't Bob Lee who allegedly assaulted the sister. But Bob Lee was the one who sort of introduced Kazar, Nima, to the party host who supposedly misbehaved with Kazar. So they had some sort of like a tiff over this situation. And, there's a video of Bob Lee and Nima driving away in a car from Millennium Tower. And then they got out and they started sort of fighting on the streets. And there was also like a paring knife that was used in this murder, and supposedly it was from the same brand of knives and silverware that Kazar, Nima Momeni's sister, had in her kitchen. So the prosecutors said that, they had some sort of tiff, and Nima Momeni was really angry, and like a fit of rage, he took that knife and planned to drive out and kill Bob Lee in the middle of the night. But the defense attorneys, it was kind of interesting towards the end, on the very last day, they showed another video which hadn't come up, during the evidence that was presented to the jury. But at the very last minute, they showed another video of Bob Lee that same night, standing outside this very exclusive club called the Battery for technology executives and other tech industry folks who are members there. So he was standing outside doing drugs. It looked like he was snorting coke. And the issue with all these videos is they're so grainy, it's really hard to know what's going on. And I'm sure the jurors must have struggled with that too. But he's standing there and he's holding a knife that looks very similar to the knife that was used in the murder. So, at the last minute, the defense attorneys presented this video and said, during closing arguments that actually it was Bob Lee's knife and, he'd used it to snort coke earlier that night, and that potentially it was just an act of self-defense on Nima Momeni's part in terms of he was attacked first and he just kind of, fought back in self-defense. And they said that it wasn't like first-degree murder, wasn't premeditated or willful. And eventually, the jurors found that it was a lesser charge. It was second-degree murder. So it wasn't premeditated, but they did think that Nima Momeni was the one who took the knife and stabbed Bob Lee.
So the prosecutors were saying that this was a premeditated murder? What did they offer to prove premeditation here?
So I think, there was some phone call that Nima Momeni and Bob Lee had where they were arguing, and they were also having this altercation at Kazar's home before they left Millennium Tower that night. So they thought that, Nima Momeni was enraged and really angry at what had happened to his sister and reacted, and in a fit of rage was the one who stabbed Bob Lee.
The defendant took the stand?
He did take the stand, and he talked about how there was this altercation and that he, in fact, while they were driving off, just happened to make some sort of bad joke about Bob Lee, potentially going to a strip club that night and not going to see his family. That enraged Bob Lee, and supposedly they had some sort of altercation in the car, and they stepped out to talk it out, and then it kind of led to this encounter with this knife coming out. And according to him, it was just an act of self-defense. He did talk on the stand about this discussion that he had in the car and how it got heated and how he made a bad joke and how that led things to sort of spiral out of control.
They did have video. Why wasn't it more helpful?
It was sort of difficult because, the videos are so grainy. It's hard to see what was going on. You can't see, who was the first one to stab or get the knife out. We don't know whose knife it was, if it was Bob Lee's or not. But there were definitely a lot of gaps. So it was definitely not an easy decision, and they took about a week or so to decide. But eventually they did find that it was the lesser charge of second-degree murder, and that it wasn't willful and premeditated, but that Nima Momeni did murder Bob Lee.
So how much time does he face?
So he faces 16 years to life in prison, and his sentencing date hasn't been set yet, but it could be a couple of months out, according to District Attorney of San Francisco, Brooke Jenkins.
And was the courtroom packed for the verdict?
Yes, it was. It was definitely packed. There were, a lot of members from both sides in terms of the families of Bob Lee, his ex-wife, Krista Lee, and his daughter was there, as well as on Nima Momeni's side, Nima Momeni's mom, who had attended the trial and was frequently seen in court. And it was kind of interesting. She was wearing black clothes, initially, and then towards the end, in the last days of the trial and during verdict watch, she was wearing all white. She sat there, stoically as the verdict was read out. And then, later on, as the defense attorneys were addressing the media, you could see her, upset and sort of wiping away tears. She said that she still believes her son is a kind and respectful individual, and she was upset by the jury's verdict.
Did he have any reaction when the verdict was read?
It was hard to see him because, he was actually sitting facing towards the judge, and we could just see the back of his head. But one interesting thing to note was when everyone stood up at the end, when the jurors were leaving, he continued to sit down. He just probably was just so upset that he didn't stand up when everyone else stood up as the jurors left the courtroom. The
defense says they're going to appeal. Do you have any idea
Yes.
what they'd appeal on?
I think they said that certain evidence perhaps was not weighed accurately by jurors, and they feel like even though it was a lesser charge of second-degree murder, not first-degree murder, that the jurors did make a mistake. So, yeah, they do plan to appeal, and they're sort of weighing their options at the moment. Even District Attorney Brooke Jenkins said that she was expecting an appeal, and they're going to continue fighting on.
Did it come as a surprise in San Francisco, the revelation of all this drug use by this respected tech guy?
So, it's sort of interesting because it's not surprising. I would think that in the world of sort of the rich, there is easy access to all of this stuff. But just taking it all in during the trial, it just struck me that all of this is actually going on, and it sort of gave us a glimpse into the lives of some of these technology industry executives and how they may party and, go to festivals like Burning Man. We know all of that stuff, but we don't know what happens on the inside. And, Bob Lee's autopsy did show that he had ketamine and cocaine in his body, at the time of his death. And then when Kazar, Nima Momeni's sister, took the stand, she talked about how the prosecutors had shared some of her text messages and she had used a lot of foul language. And she said that because she was taking drugs so much that sometimes her messages were really sort of aggressive or had bad language because she was doing all these drugs.
You got to look into another world there, Malthi. Thanks so much. That's Bloomberg legal reporter Malthi Nayak.
And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.